In the landmark 1842 case, Prigg v. Pennsylvania, Justice Joseph Story intended to expand federal power. Instead, he further cemented James Madison's strategy for states and individuals to bring down federal programs. Margaret Morgan was a former slave living in Pennsylvania after her owner set her free, but she was never officially released, and the slaver's widow later decided she wanted to reclaim her so-called property. Edward Prigg was the slave catcher who snatched Morgan and her child in Pennsylvania and took them back to Maryland. But in the process, he failed to follow the procedures set forth in Pennsylvania's personal liberty law. Pennsylvania authorities charged Prigg with kidnapping. In response, Prigg asserted the Federal Fugitive Slave Act of 1793 trumped Pennsylvania law, arguing the state had no authority to interfere with his federally endorsed slave catching. When the case reached the Supreme Court, Justice Story agreed with Prigg, in part. Story held that Congress had the sole authority to legislate in the matter of fugitive slave rendition, and state governments couldn't actively interfere in any way, not even to stop kidnapping. Ironically, though, Story's plan to further cement federal dominance actually backfired. He left an Easter egg in his opinion, which said that while states couldn't actively interfere with federal slave rendition, they also couldn't be forced to help the federal government either. He wrote, "The states cannot be compelled to enforce the Fugitive Slave Clause, and it might well be deemed an unconstitutional exercise of the power of interpretation to insist that the states are bound to provide means to carry into effect the duties of the national government, nowhere delegated or entrusted to them by the Constitution." In the coming years, northern states seized on the case and used it strategically to nullify the next Fugitive Slave Act of 1850 in practice. They did this primarily by actively refusing to cooperate with or provide resources to federal agents trying to enforce the hated federal act. This was the same strategy that James Madison advised back in 1788. Writing in Federalist No. 46, Madison recommended a refusal to cooperate with officers of the Union as a way to limit federal power and bring down federal programs. While the Supreme Court has often gotten things wrong on the Constitution, Joseph Story's opinion in Prigg v. Pennsylvania has never been overturned. In fact, it has been reaffirmed by the court in a number of cases spanning more than 150 years. This has helped cement James Madison's advice as a legitimate and essential part of the constitutional system.